Hello, and welcome to Defending Suspects at police stations. Thank you very much for joining us this evening. Please feel free, if you'd like to turn your camera on and contribute, then please do, because the purpose of this evening, and I think it will be no more than an hour, is just to talk about a few of the current cases that are around and that we thought might be of interest, particularly arising from the last update. And also just to look briefly at what's coming at us in terms of the Police Crime Sentencing and Courts Bill, as far as police stations, in particularly bail is concerned. With me tonight are Professor Ed Cape, who, as you know, is a legend and perhaps doesn't need much more of an introduction other than saying that he is the author of much of what many of us know in terms of what we've learned about going to the police station. And he has done that in many ways, and not least through the book, which you all know has been around for nearly 30 years now, helping us to do our jobs better and challenging us to do it as well as we can. If you want to know more about Ed's bio, buy the book, of course, or there is information on the LAG website. Also, Matthew Hardcastle, who is a senior associate at Kingsley Napley. He's also the author for the Blackstone's Almost Sister book, which will help you at the police station. Also, again, more information about him in the bio at the front of the book and on the LAG website. My name is Sandra Paul, and I am a solicitor at Kingsley Napley. Also, and between the three of us, the last edition of Defending Suspects, published towards the end of last year, represented our combined efforts to try and update that text, which I hope will keep you going along with the updates for the next few years. Excellent. I'm going to kick off tonight, and I want to just spend 5 or 10 minutes sharing with you some of the initial thoughts that we have about the Police Crime Sentencing and Courts Bill, at least so far as issues relating to pre-charge bail are concerned. And I don't know, I presume that most of the people on this call will have spent some time thinking about and reading about this bill. And I think it's one of the most difficult bills that I've read in a long time. It covers a huge number of areas and heralds quite significant changes to the way we live our lives in this country. There's a lot in there, and I think we'll end up coming back to this piece of legislation either before it's enacted or shortly thereafter, because there are other aspects that affect the police station. But for tonight, I just want to talk about the changes in respect of pre-charge bail. You can see from the slide here what the position was pre-2017, and then where we ended up as a result of the legislation in 2017, and then again what we actually worked with in 2019 and where it's going ahead. And we'll make sure that that slide is available on the LAG website, just in case you're interested in the history of where we've come from. The proposed bill, what we had in 2017 under the Police and Crime Act was the government saying this situation regarding people being on bail for ages is not good. I think there were some quite high profile examples of how wrong that looked and felt, and we could have probably told them that as well. But they changed the law so that there was then a presumption that people would be released without bail and under investigation. And there were some, that kind of arguments about why that was a bad idea have been well rehearsed. And I know that LAG, ED, the LCCSA, all those other representative groups, and us all individually told them why that was going to be a bad idea. But do they listen? Do they? No, they don't. And as I said, the kind of intention that it was going to prevent people languishing in legal limbo for years on end, and kind of rebalance the use of police bail in terms of fairness. It just didn't work. And what the government seems to be doing here is almost an absolute kind of about face. And that in part is political. We know what's happening in our country politically at the moment, but also I think in respect of pressure from kind of victims groups. What we have is a set of reforms which are going to be called Kay's Law, and it's called Kay's Law because of a woman named Kay Richardson, who was murdered by her ex-partner, who was released under investigation despite a history of previous domestic violence. And what it's intended to do is to encourage greater use of pre-charge bail where necessary and proportionate. And we get some help with that a little bit later in this bill. And also to increase the engagement of victims. And one of the quotes I read from Priti Patel said that it intended to put victims at the heart of the bail system and ensure suspects are closely monitored. That's what it's looking for. I don't know where the extra monitor is going to come from. I haven't seen anything that says that the police will have additional powers in terms of supervising bail or imposing monitoring, but let's see. What it intends to do is take away that presumption, as I said, and create a neutral position. And so it's seeking to encourage the use of bail more often. So it doesn't actually say that. It says designed to encourage the use where it's necessary and proportionate. But I think that that's the underlying trend, and that's the way that things are going to go. And so there'll be much more push for police officers to make an individual assessment about this particular case, looking at specific risk factors that are set out or are going to be set out in the legislation. There's also going to be a new duty to seek the views of the alleged victim. I was quite tickled actually when I saw that they did actually say alleged victim because some of the precursors just said victims. So the alleged victim is going to be consulted on pre-charge bail conditions, both the imposition of conditions, and then when there are any changes in bail conditions, there's a must in the legislation that says that they should be consulted, and that the person who is making the decision about bail must be informed of their views. Now, one of the other things that we found that was really interesting in this was the idea that the College of Policing are going to be given the power to make or issue statutory guidance to establish consistency across all forces in how pre-charge bail is used. What I had originally anticipated when I was reading about this was that there'd be like a new APP, so an approved professional practice, some sort of guidance. But that's not what's happened. They've actually delegated those powers to the College of Policing to draft that statutory guidance. So that it simply needs to be laid before Parliament. There's no more discussion about it at that stage. They just say, here you go, will you enact that? And they go, fine, no problem, not going to ask you any questions. And when we were talking about it, and Ed is the oracle for so many things, but we couldn't think of a similar situation where that kind of power to provide statutory guidance has been delegated to the police. And it's one of those things that I think we have to keep an eye on, and I'd be interested to see if it comes up again. But it's an unusual level of autonomy to give to the College of Policing in this way. And I think there was some kind of discussion about it being harder to, these are circumstances that might change over time, and then you have to come back and get the legislation changed. That doesn't make sense. I'm not so sure about that. I think there's something much more insidious going on there, but we'll have to wait and see. And so it describes the need for the police to use and impose these bail conditions, or consider them at least, in those cases that they refer to as high harm, No definition of that really, but I expect that to be something like, domestic violence and sexual violence, those sorts of cases. So what's actually going to change? Firstly, we get some more information, as I said, regarding what necessary and proportionate means. So you're going to get a new section 30A, B, so it will be 30B inserted and a new section 50B in place. And they just provide more guidance. So it says, like, in determining whether releasing a person on bail is necessary and proportionate in all the circumstances, the custody must take into account a number of things, and particularly the need to secure that person's surrender to custody, need to prevent offending by the person, safeguard victims, crimes and witnesses, take into account the vulnerabilities of the victims, etc. The need to safeguard the person, taking into account the need to the vulnerabilities that that person might have as identified by the custody officer, and then the need to manage risks to the public. And it also then describes who are that group of additionally vulnerable victims, and describes them as people under the age of 18, so children, and then people who have who we would otherwise describe perhaps as adults with either learning needs or mental health needs. So those who find it difficult to understand communication effectively, physical disability or disorder. There's a list of people who would form that group of victims. Right, just need to change the slide. Okay, the substantive bits that will affect most of us who go to the police station are these really. As I said, firstly, the bail presumption is now a neutral position, so that's removed. The applicable bail period, so at the moment we have 28 days for that first bail period, that's the maximum there. It will now be 3 months for that initial bail period. At the moment, that can be authorised by a custody sergeant with the assistance of an inspector or above. What's going to happen is that initial 3-month period can be authorised by the custody sergeant. Weird, right? It's a long time. And it's interesting because it says, well, the custody sergeant is independent of the investigation, and as if that is some sort of safeguard to having this quite long period that can be the initial bail period. So it's custody sergeant or an officer of the rank of inspector or above. Then you have that first extension at the moment, 28 days, can be extended to 3 months. What's going to happen under the bill or the Act as it is then is that you'll have an initial, that initial period can be extended to 6 months. And for that, you need an inspector or above to authorise. There can be a further extension. At the moment, you would be at 3 months and therefore need to go to court to get that period extended. What will happen then is that that second bail extension can be extended for up to a total of 9 months, but that must be approved by a superintendent or above. Then, of course, you have any further extensions beyond the 9 months now will be governed by the Magistrates' Court. So I think it's quite a big shift in terms of the time. We're kind of getting much more back to the long periods of being on bail without any action seeming to take place. Now, what the legislation is likely to, what it suggests at the moment in the bill is that the suspects and or their legal representatives should be required to, should be permitted to make representations in respect of any of these extensions of bail. Same process as now, insofar as the decision to extend bail has to be taken before bail actually expires, and they're supposed to ask the views of the suspects, their legal representatives, the complainants. All of this has to be organised in time. I think that where we will see the detail of how that's actually going to happen, what's the mechanics of that, will be in the guidance. I hope and anticipate that there'll be some sort of consultation about the guidance, so that the practicalities of that are something that we can feed into. I also wonder, what we can see is some diminution in the level of visibility that we have as defence lawyers. At the moment, one of the things I like about the 3-month stages is when it's going to be an application, I get to see what the police have been doing. I get to interrogate that in some way. That I don't think is going to be available in the same way in the future, but I hope that we will start off at least by expecting that to be there and contributing to any consultation that exists. We will certainly keep an eye on it and see what actually happens. In non-standard cases, so before you just had the SFO, now you have the SFO, NCA, HMRC, FCA. They all have slightly different time periods for those extensions, so they can extend to 12, 18 and 24 months. And I think that generally, I hope, is a useful pen picture of where we're going. I think one of the other things about the making representations for extensions that I should have mentioned is, one of the things you can do is, of course, go back to all the things that we know about the Attorney General guidelines in terms of asking for disclosure, so you can usefully make representations regarding that. But I think that that's just like a whistle-stop tour of what the bill looks like in terms of what's coming next. I think, if that's okay, I can't see any questions with the view that I'm in anyway, so perhaps what I'll do is stop my video, and then Matt, I think you're next.
I am, please, and sorry to do the traditional 5 o'clock presentation, but can I have the next slide? Well, thank you. So the reason we start off with section 24 is because the first update for 2021 ended up being a bumper edition for cases where there was a challenge to the lawfulness of an arrest. And so what I wanted to do was to take this opportunity just to review the essential components of a lawful arrest under section 24. The correct approach to applying section 24 was authoritatively set out in the case of Parker, which is on the next slide. On the Parker slide, the fetching green colour will indicate the subjective questions, and the deep pink, potentially purple colour, will be used for the objective questions. As you can see, there are 3 parts of a lawful arrest, each with a subjective and objective component. Firstly, the offence, Parker questions 1 and 2. Subjectively, did the arresting officer suspect that an offence had been committed, and objectively, were there reasonable grounds for that suspicion? Secondly, in respect to the suspect, which is Parker questions 3 and 4, did the arresting officer suspect that the person arrested was guilty of the offence, and objectively, were there reasonable grounds for that suspicion? And finally, necessity, Parker questions 5 and 6. Subjectively, did the arresting officer, for a section 24(5) reason, believe that it was necessary to arrest the person in question, and objectively, were there reasonable grounds for that belief? So in applying these Parker questions, you're going to need to have a good understanding of the tests for suspicion, reasonable grounds for suspicion, and necessity. Starting with the slide on suspicion. This is most likely to be considered through the prism of reasonable grounds to suspect, so I'll limit my comments to just mirroring those made by Mr. Justice Saini in McGee and McGee. He cited this paragraph with approval, and his introductory remarks were, it is important to underline how low a hurdle suspicion is. Moving to the slide for reasonable grounds for suspicion. Again, we're still dealing here with a low threshold test. As set out in Parker, it is a far lower test than a prima facie case, and it is far less than the evidence required to convict. It may well include matters which cannot be put into evidence or matters which are based on assertions which turn out to be wrong. In forming a reasonable suspicion, officers should take into account any facts and information that may dispel that suspicion. Notes for guidance 2 and 2A provide some illustration, including that the exercise should include a consideration of claims of innocence and that an act was done in self-defense. The final sentence here is important, and on the next slide we will see the judgment of Mrs. Justice Collins Rice. And now, while this was dealing with the consideration of necessity, an arrest is a form of operational decision making, and the court will often recognise that decision making of this kind tends to be frenetic. The slide shows Miss Justice Collins Rice's more eloquent statement of that fact. While this was in the context of necessity, in my view, the principle holds for the wider assessment of whether an arrest was lawful. It is not an abstract thought experiment, but it is a practical balancing exercise that will recognise operational realities. As we move on to consider necessity, I just want to pause and look at the slide coming up, which involves Rashid and the Chief Constable of West Yorkshire Police. So the test so far has been comparatively low hurdles, or as I've termed them, a low threshold test. But necessity is a different beast and is a comparatively high hurdle. In the next slide, we cover necessity, and this has been an area of focus for a number of years, and I think it will continue to be an area of development in the coming years. We've all seen a period where there have been a large proportion of voluntary interviews, but with the changes to police bail, which Sandra's just been talking about, I think it's reasonable to assume that the pendulum will be about to swing back to the use of arrest. And if I'm right, then arguments about the necessity of arrest will become even more frequent parts of our job. Hayes and TL are the classic statements of the necessity considerations. The policeman must honestly believe the arrest is necessary for one or more of the identified section 24(5) reasons, and his decision must be one which, objectively reviewed afterwards, according to the information known to him at the time, is held to be made on reasonable grounds. It should be emphasised that the underlying concept in section 24(5) is that of necessity. It cannot be envisaged as a synonym for desirable or convenient. For present purposes, the issue may be formulated thus: should the court, in the exercise of its review function, conclude that an arrest was necessary to allow the prompt and effective investigation? Considering necessity would be a talk in and of itself, so I'm going to completely shamelessly direct you to paragraphs 2.18 to 2.22 of Defending Suspects, where we review and distill the necessity considerations and of Code G. If we can move on to my last slide, please. I can't leave a discussion about necessity without considering the use of an arrest to obtain a mobile phone. Section 32 provides power of search, but it's noted in Rashid that that power is limited. The short point made by Mr. Justice Lavender in that case is that Section 32A is a power to search an arrested person, but it is operative subject to subsection 5, which states that a constable may not search a person in exercise of the power conferred by subsection 2A unless he has reasonable grounds for believing the person to be searched may have concealed on him anything for which a search is permitted under that paragraph. So it's just worth noting here the test for this is a reasonable ground of belief rather than a reasonable ground of suspicion. And I'm sorry, I do have one more slide, albeit in the context of search warrants. In the case of EastEnders Cash and Carry, it was held that belief is a higher threshold than suspicion. I think we're now moving on to Ed.
Thank you, Matt and Sandra, and good evening, everyone. So I'm going to concentrate this evening just on one case, R versus Al Jarian, which, as you can see, is a case decided back in March 2020. Now, it has to be said that this case is, well, let's say, put it politely, it's been a mess from the very outset. And the reason that we're only talking about it now, sort of over a year ago since that Court of Appeal decision, is that it was ordered that the judgment should not be published until, because what happened was that the appeal was successful and the court ordered that there be a retrial and that there be an arraignment within 2 months. That didn't happen. And then in December, sort of after 9 months, the prosecution applied for permission to arraign beyond the 2 month time limit. And ultimately the court refused that application. And then the restriction on publishing the original judgment was lifted. So that's why we only relatively recently got to know about it. So, and it's the March 2020 decision which I want to have a look at because it raises some important issues. Firstly, about the issue of mental vulnerability and the decision by a custody officer to determine whether a suspect is mentally vulnerable and therefore whether an appropriate adult should be called in. But it also raises the question, which there have been very few cases on, which is concerning section 77 of PACE, which is the special need for caution, where a prosecution relies predominantly on a confession by a person who is mentally disordered, and where that confession is made in the absence of an independent adult. And what I'm going to say is that what we see is the Court of Appeal making an unfortunate confusion between, firstly, on the one hand, the question of mental vulnerability, and on the other, mental disorder, which have different meanings, but which the court didn't seem to understand. So very briefly, this was an appeal against conviction for possession of a firearm. The police, acting on information, had raided the appellant's flat where they found multiple cannabis plants being cultivated. And they also, on searching the property, found a self-loading pistol under a sofa cushion. As well as the defendant, the police found another person at the flat against whom they took no action. And when the police entered the flat, they looked out of the window and there appeared to be 2 people running away. So they arrested the defendant and one other person, and ultimately the defendant was charged with cultivating cannabis and possession of a firearm. So he pleaded guilty to cultivating cannabis and not guilty to possession of the firearm. Now, in relation to that offence, the prosecution case was largely based on a confession that he made at the police station, where he told the police that he knew the gun was in his flat and that someone may have left it there on a previous occasion. But the critical thing was that he knew it was there and was able to give a description of it. At trial, he said that he believed that the gun had been left in his flat without his knowledge by one of the men who'd run away. And he explained that he had not told that to the police when he was interviewed for 2 reasons. One is that he suffered from mental problems and had recently been diagnosed with diabetes and hadn't been taking his medication and therefore was not thinking properly. And also, secondly, that he was scared about repercussions from the other men if he told the police that the gun belonged to them. So that was basically his defence in relation to possession of the firearm. And that was his explanation for why he had said something different to the police on being interviewed. And it's worth noting at this point that he had asked for legal advice. The solicitor had attended at the police station, but the solicitor had not attended at the police interview. It appears that the defendant didn't want the solicitor present at his interview. And it was also the case that, as we'll see in a moment, the custody officer decided that there was no need to call in an appropriate adult. So he was convicted. the judge decided that there had been no breach of Code C, paragraph 1.4, which concerns the obligation to call in an appropriate adult for a person who is mentally disordered or mentally vulnerable. And the judge also decided that the confession was not excludable under either section 76 of PACE on the grounds of reliability or unreliability, and did not exclude it under section 78 either. So on appeal, the defendant argued that the judge had erred in concluding that there was no breach of Code C paragraph 1.4, and also argued that the confession should have been excluded under either under section 76 or under section 78, excuse me, under section 78. The Court of Appeal essentially, with regard to the issue of breach of Code C, agreed with the judge. As we'll see in a moment, sort of Code C, well, actually, let's move to that next slide. So what does Code C paragraph 1.4 say? Or rather, what did it say at the time? Because as I'll say in a moment, it has been subsequently amended. But Code C 1.4 provided that if an officer has any suspicion or is told in good faith that a person of any age may be mentally disordered or otherwise mentally vulnerable, then in the absence of clear evidence to dispel that suspicion, the person shall be treated as such for the purposes of this code. And what that meant, apart from anything else, is that they should not have been interviewed in the absence of an appropriate adult. Now, the defendant or the appellant argued that the question of whether there was clear evidence to dispel that suspicion only applied to the first clause of whether an officer has any suspicion. And what they argued is that if the custody officer or the police generally are told in good faith that a person may be mentally disordered or otherwise mentally vulnerable, then they must be treated as such. But the Court of Appeal said that the clause about clear evidence to dispel the suspicion applies to the whole of that first part, so that even if the custody officer is told in good faith that the suspect suffers from a mental disorder or is mentally vulnerable, then that can still be displaced by there being clear evidence to dispel that. Well, it says clear evidence to dispel that suspicion, but that would include even though they are told in good faith that the person is mentally disordered. And so the Court of Appeal said, in effect, therefore, that there was no breach of paragraph 1.4, because although the defendant had told the police that he suffered from depression and had other history of other mental problems, and including self-harming, the forensic medical practitioners said that yes, he did suffer from depression, but that he was fit to be interviewed and didn't need an appropriate adult. And in fact, the custody nurse, he was seen by 3 separate forensic medical practitioners, but the first, the custody nurse, had noted, told the custody officer that the appellant had type 1 diabetes, depression, anxiety, personality disorder, and a history of self-harm, but then went on to say that the appellant was being jolly and engaging well. And so the custody officer took the view that therefore there was no need to call in an appropriate adult. And it's worth noting at this point that the Mental Health Act 1983 Code of Practice includes depression and personality disorder as being conditions that can fall within a definition of mental disorder. So it would seem to me that the Court of Appeal decision is questionable, because quite clearly, and the custody officer knew this, he was suffering from depression and other mental problems. That is a mental disorder, and therefore 1.4 says that if a person is or may be mentally disordered, they must be treated as such. and simply to say that the person nevertheless is able to engage, is jolly and engaging well, doesn't negate the fact that he was mentally disordered within the definition, and the custody officer knew that. So certainly from my point of view, I think the decision of the Court of Appeal is questionable. Important just to raise the issue is because, as I said, the Code C, or this provision of Code C, paragraph 1.4, was revised in 2018. And it now refers to an officer having any reason to suspect that a person of any age may be vulnerable. In the absence of clear evidence to dispel that suspicion, they must be treated as such. So we still have that clause about absence of clear evidence to dispel that suspicion. But the definition of a person who is vulnerable for the purposes of whether there should be an appropriate adult is wider than it was under the previous drafting of Code C. And it also places further obligations on the custody officer, because it goes on to say that in order to establish this, the officer must make reasonable inquiries to ascertain what information is available. And in this case, for example, 2 years previously, he had been detained under Section 136 of the Mental Health Act. That should and almost certainly was on his record available to the police, and that would have been another indication that he was therefore mentally vulnerable for the purposes of Code C paragraph 1.4. And then just to complete that, what paragraph 1.13d goes on to say is that in making reasonable inquiries, the officer must be considering whether the defendant or the suspect at that stage has any difficulty in understanding or communicating effectively, understanding of the significance of what they're told or what they say in reply, or being prone to confusion. So I think the takeaway from that is, firstly, that the issue is not whether they are engaging well or jolly, which I find a very difficult thing to understand that a forensic medical practitioner would think was relevant. But the question is, are they mentally vulnerable? If they are, then they must be treated as such, and that would include the requirement to call in an appropriate adult. The case also raised the question about the importance of the defence lawyer and what they do at the police station, because it was particularly noted by the trial judge that the solicitor who had gone to the police station to advise the suspect did not suggest that an appropriate adult should be present. And as I say, that was something that the trial judge placed emphasis on, and it was something that was also noted by the Court of Appeal in their judgment. Now, we don't know what the defence lawyer knew about his suspect and what he'd been told by the suspect, but it does appear from the judgment that he did see the custody record, and therefore the custody record did note that the defendant did suffer from depression, and certainly that should have put the defence lawyer on notice of the potential need for an appropriate adult to be called in. But we don't know, this is not a criticism of that lawyer, because we don't know what his instructions were. And it does raise a question, excuse me, to which I'm going to raise the question without an immediate answer, is, well, what does a defence lawyer do if they have evidence that their client is mentally disordered or is mentally vulnerable, but the client either tells them not to disclose it or informs the lawyer that they don't want an appropriate adult? That raises, I think, a critical and very difficult decision for what the defence lawyer should do in those circumstances. And then finally, I want to move on to the issue about the other aspect of the decision, which was that the Court of Appeal decided that the trial judge should have given the jury the warning for a special need for caution under Section 77. And again, I'm afraid I think the court got this wrong. Let's just have a look at section 77. What it says, and it's still the same. I don't think it's been amended ever since PACE came into force or was originally enacted in 1984. Where a case depends wholly or substantially on a confession by an accused who is mentally handicapped, that's the expression, and the confession was not made in the presence of an independent adult, the court must warn the jury of the special need for caution. And so what the Court of Appeal said is that the judge didn't do that, and therefore that was one of the major reasons why the appeal was successful. But is that correct? And it seemed what the Court of Appeal did was to assume that mental disorder is the same as mental handicap, which it clearly isn't. Excuse me. Yes, so the classification of mental handicap is defined in PACE section 77, subsection 3, as being in a state of arrested or incomplete development of mind, which includes significant impairment of intelligence and social functioning, which in modern terms we might say describe as a person having learning difficulties. Now that is clearly quite different from a person who is psychotic or suffering from depression, for example, which was the case here. But as I say, the Court of Appeal said that, in fact, what they said was that as it says there on the slide, that this was a case where the appellant had depression, a mental health disorder, which that part is correct, and was without a solicitor or an appropriate adult in interview. In such circumstances, a warning to the jury that there is a special need for caution should have been given. And they were referring there to section 77. But as I say, section 77 does not refer to a mental health disorder. It refers to a mental handicap, which is something, as I've said, which is different. But I think the major sort of takeaway from that is, from a defence lawyer's point of view, is that when advising a client at the police station, then it's very important to be aware of the potential for the client to be mentally vulnerable for the purposes of Code C paragraph 1.4. And now that there are these extra obligations on the custody officer to investigate evidence as to whether a person is mentally vulnerable, that the defence lawyer needs to consider whether they should be asking the custody officer what kinds of investigations they have made, so they are in a better position themselves to advise their client about whether they should be ensuring that they are treated as such and an appropriate adult is called in. Thank you.
Ed, thank you. We have about 15 minutes left, and what we wanted to do was to open this up to questions. So if anybody has anything that they would like to fire at us, please add it to the chat function. And then either Ed or Sandra will answer the question. And the great benefit of doing this remotely is neither of them can kick me under the table when I put it their way. So at this point, it is very much over to you.
I think as well as questions, it would be interesting to hear what people think about some of the issues that we've talked about. So it doesn't have to be a question. If you just have any comments about anything that we've raised or anything that's around at the moment, please do.
So we'll start with Greg's question, which is I think very topical, which are whether we have any thoughts about remote attendances. And I think if we can start with Ed, because I think you have some very good points to make, and then potentially move to Sandra because you've had the practical experience.
Yes, I should preface what I say by saying, firstly, I have no practical experience of remote attendances, and I wasn't faced with that awful choice about whether I should attend the police station or not. But I have to say that it's something which worries me considerably. And what has concerned me is some lawyers on Twitter, etc., have been saying that they're quite happy with remote attendances, and some even saying, you know, this is the way forward. This is how we should be doing it in the future. And perhaps the first thing I would say is, well, yes, I can understand that there are cases where remote attendance is perfectly okay. But I think that's probably a very small minority of cases. And I think we have to remember why it was so important to get lawyers into police stations in the first place. And in many respects, I think some things haven't changed. And what, you know, if we go right back to the origins of PACE, that the Royal Commission on Criminal Procedure had advocated, had recommended that this be the case, that a suspect should have a right of access to a lawyer, excuse me, and that the lawyer should in effect have a right to attend the police station in person and attend the police interview, which, by the way, is still not the case in many other countries. And there was a whole history there of the police misusing this opportunity to create evidence against people and to ill-treat some people, particularly some suspects of, if you like, you know, from certain sections of the community. Now, it may be that things have changed to a certain extent, but we have so many cases of late where, not necessarily in the police station, but where the police have ill-treated people. And therefore, for defence lawyers to effectively withdraw from the police station, I think is something which is both wrong and very damaging. And I think the significant thing now is working through how do we get back to a position where attendance is the norm. Now, clearly, for as long as the legal aid agency are willing to pay on the same basis, whether it's a remote attendance or not, then the incentive, the financial incentive is not to attend. But simply encouraging the legal aid agency to go back to the previous arrangements is not enough, because, you know, as we all know, the from a legal aid perspective, this, well, let's put it this way, the successive governments have not prioritized legal advice at police stations, have not prioritized legal aid at all. And therefore, just going back to the previous position is not enough. But I do think that we and the Law Society and other organizations have at this point to be seriously working on the issue of how we get lawyers back into police stations.
So, I mean, I agree with you, Ed, in terms of the things that you've said. I completely understood and was hugely grateful for the opportunity to attend remotely when we were in that state of flux. Everything was going mad, the world was going to end. And having that option there in some cases was an absolute lifesaver. And I think that if that wasn't in place, people would have been without representation, and that somehow is worse. And so it's better than nothing, but it's nowhere near, in my experience, as good as being at the police station. I just fundamentally don't trust the police. And there is something about being there and being able to see things unfold, to assess for yourself, that is just so difficult to replicate remotely. You just can't do it. And I've had conversations with colleagues who've attended just with a phone line only, so that you can't even see anything. And I haven't adjusted very well to being able to do that remotely. So that certainly we've said for children and vulnerable adults, somebody will attend. And for all other cases where it's possible for someone to attend, that we try to do that. I understand the pressures. I also think I'm also a little bit worried, and perhaps this is with you, Ed, as well, that if it goes on for much longer, that someone's going to say, well, what's the point of us? And we'll have a situation, we'll go, well, you just send it to PDS. Why do we need to pay for people to go to the police station when you can just have telephone advice for the whole thing, rather than just for those limited number of offences where it's an attendance is no longer required or permitted now. So just out of self-preservation and in terms of preserving our clients' rights, I think we do have to get back, and I think the energy that we put into making that system now, we can turn to making it as safe as possible for us at the police station, and continuing to try and improve the remuneration. I think that report, when I read it, I can't remember what the name of the organisation was.
Fair Trials.
Fair Trials. You know, at first I was like, really, oh, what are they saying? But then when you listen to the detail, you kind of go, wow, that's scary.
If I could just follow on from that, just to make the point, which Greg Foxsmith has reminded me, which is that Fair Trials is conducting some research along with others into this issue, and they are looking for lawyers to share their experiences. And I think Greg, if I remember correctly, yes, Greg's put up a link to the survey in the chat function. So if you are interested in engaging in that, then have a look on the chat function. You'll see the link where you can say something about your own experiences of it.
Thank you.
James, James's comment. I don't trust the police either. To be honest, love it.
Ed's points on engagement, in fact, leads quite nicely onto the question that's been asked by Lana, which is how will the funding for defence solicitors work for the new pre-charge engagement process? Because the government response to the consultation period on funding has recently closed, and there were 12 respondents to the consultation. The government have decided that they will keep the figures as they proposed, so they will be looking at hourly rates of £51.28 for London, 47.45 out of London, subject to an upper limit of £273. So you're talking there at about 5.5 hours work is what the government think pre-charge engagement will take. In terms of the process, it is still meant to be that there will be a written agreement between the police and the defence team that pre-charge engagement would be of utility to the case. I think we are coming close to the end of the session, but if anybody else has anything that they would like to add.
Well, there is a question from Rishi about how the bill will affect pre-charge bail for youths. Now, from my reading of it, there's no distinction made between adults and youths. It's just the same provision. And so, unless Sandra knows differently, since the provisions are the same, then from a legal point of view, there is no distinction. Is that right, Sandra?
That's my reading as well, absolutely. And I think that I think there's going to be this increased use of safeguarding the person, taking into account their vulnerabilities. That kind of like for your own good. We're doing this. I had a police officer say that to me today regarding a 15-year-old. Didn't want him to go back to school for his own good in case other people thought badly of the allegation made against him. Yeah, we had a conversation about it.
For those of you who don't know, Sandra, I've seen those conversations. They're not ones you want to be on the other side of.
Sorry, if we've got time, I just want to pick up on this comment from Tommy. It says, in terms of remote attendances, some police forces are insistent on consultation taking place over the phone, with the call being connected to the speaker in a client's cell. Well, my immediate response to that is that as far as PACE is concerned, PACE entitles the suspect to consult a solicitor effectively in person, and although it doesn't say. It doesn't quite use that terminology, but it's quite clear, and the understanding has always been that a suspect has the right to face-to-face consultation with a solicitor. And it seems to me that if police are trying to prevent face-to-face consultation where the lawyer wants to provide it, then that would be unlawful. And, well, yes, I mean, the various kinds of actions that should be taken, but it seems to me that that would be unlawful on the part of the police in those circumstances.
I mean, the practicality of that might include ensuring that your request to attend has been noted on the custody record, asking to speak to the duty inspector. You know, I know this is all more work for us, but that might be some of the routes. I've had colleagues who've just turned up and you know, banged on the door, work out how long it is until the review is due, make sure that they know that you want to make representations in person. You know, all those things are things that we can do when we're met with that sort of response.
One of the questions we had is whether we will be doing a talk like this again, and the answer is yes, we very much hope so. Subject to there being sufficient interest, I think our intention is to try and do a talk to follow on from each edition of the Police Station Update, which comes out twice a year. And there may be other talks through the year. So if this is something that you found helpful or found enjoyable, then any feedback to Legal Action would be greatly appreciated, because we do this work, and of course Legal Action do it because of our commitment to you all, and we hope that it has been a helpful session.
Thank you.
In Jobs and Homes, we meet Brodie, Ronald, Schwartz and Kaylee. These characters are all united by one fact. They all stood on the very edge of losing their home in 2020. Jobs and Homes is a memoir of representing workers and tenants day after day during the pandemic. It tells the story of the real people behind the cases. Through the pages of the book, you will meet the tenants and workers and landlords and bosses. There are workers who want the court to recognise the injustice they have suffered, but find the law struggles to satisfy this demand. And there are tenants who are minutes away from losing their home and facing absolute poverty, street homelessness or worse.